Brett Hudson.
Thank you, Mr. Speaker, and it's wonderful to be back after the summer recess. It's good to see you again in the chair, Mr. Speaker. I'm looking forward to speaking on this, the Civil Defence Emergency Management Amendment Bill. This is a bill that addresses better recovery from New Zealand's most frequent emergencies, which are those of a small or moderate scale. It's part of a wider review. This is the first phase. The second phase will address the legislative framework required for recovery from large-scale emergencies, such as the Christchurch earthquakes. But as acknowledged, this is addressing those which are most frequent in New Zealand, those emergencies that are small to moderate scale. And what it's doing at the heart, if you will, Mr. Speaker, is establishing a legislative framework for recovery management, providing a mandate for recovery managers and requiring high-level preparatory recovery planning. Now, what we've seen, and we have continued to see with most of the smaller or moderate emergencies that we experience in New Zealand, is a very, very heightened focus, as you might very well expect, on response. But the transition from response to recovery hasn't always operated as smoothly and effectively as we and those who have suffered loss and injury and other issues might expect. So this bill will seek to address that by supporting a seamless transition from response to the initial recovery phase. It establishes a transition notice mechanism that will make some emergency powers available for a specified period of time. And it's those emergency powers, Mr. Speaker, that will enable those recovery managers to move swiftly and effectively into that most important next stage, which is the response has been addressed, but now it's time to recover and to address some of the major damage which may have happened even in only a moderate scale emergency. Because we have got a really good example actually in the Manawatu-Whanganui region following the severe flooding there. An event that was classed as a moderate emergency, but which actually showed us that the clean-up and recovery work involved a huge amount of work. Something that perhaps we weren't quite as prepared in the transition to as we should have been. So the new law will give clarity to those leading the work. It will help ensure that it can be carried out swiftly and as effectively as possible. It will give them the appropriate authority they need to undertake works. And sort of things that might enable, for instance, are carrying out works to clear roads and other public places, removing and disposing of dangerous substances and materials, and actually entering into premises. One of the things that was heightened, I think, in that particular Manawatu-Whanganui event was the issue with seeking to have people leave their residences for their own safety, and a lack of authority for those leading the recovery to actually ensure that that could happen. So these amendments will seek to address that, and if it is to save life, prevent injury, or to rescue or remove injured or endangered persons, those recovery managers and teams will have the due authority that they would require to enforce those relocations. But it is important when we are considering granting some quite considerable powers, that we make sure that we have pragmatic steps to make sure that they won't be extended or abused. And for instance, one of the things that we'll be doing is stipulating that the powers can only be used for a defined transition phase, and that they must be proportionate, reflecting the consequences and scale of the emergency. So they must be fitting, and they can only be for a defined period of time. Another part which I see in this, which has perhaps not been canvassed that strongly, but I think it's important as we are giving these additional authorities and powers to recovery managers, that the Act has compensation provisions for such emergencies, particularly when damage is caused by emergency management officials in undertaking their actions. There was, I believe, a small gap that during the transition phase, the Act as it currently stands may have prevented such compensation being payable to land and property holders. So that is being addressed in these amendments, so that if the officials do cause loss or damage during the transition phase, that those property owners can be recompensed for that. So I think, Mr. Speaker, I think it's a very pragmatic, sound. It's very smart thing for us to be doing. It is part of a wider review that will also address larger scale emergencies, and I commend this bill to the House.